Hi, this is a slideshow for chapters 7 and 8 of our textbook. The big ticket item for chapters 7 and 8 is intellectual property. Last week in chapters 5 and 6 we looked at a defendant who was stealing stuff, a car, a watch, a wallet. But what if a defendant steals an idea? There are four big areas in intellectual property, and there are some very expensive attorneys who specialize in each: trade secret, patent, copyright, and trademark. Let's start with trade secret. An idea can be property just like the $20 bill in your wallet. You show your ownership of the $20 bill by keeping it safe in your wallet. If you leave the $20 bill on the sidewalk in front of your house, your ownership rights are not looking too good. Okay, so if a defendant comes along and takes the $20 bill from your wallet, that's conversion. Remember, conversion is the tort of theft. It's also theft, which is the criminal charge. And you can sue this defendant in a civil case and get the $20 back on conversion. And the state can sue him in criminal court for theft to discourage this kind of behavior. But what if defendant comes along and takes the $20 bill from the sidewalk in front of your house? You can still try suing him, but you're going to run into the legal principle, finders keepers, losers weepers, and good luck trying to get the Attorney General to prosecute the case. The same sort of thing applies to ideas. If it's your idea, just like your $20 bill, and you didn't steal it from someone, you have an ownership right in it. You show that right by keeping it secret. You kept the $20 bill in your wallet. You keep your idea in your head, or among a select group of people, or in a private notebook, or, most commonly these days, on your computer. But just like the $20 bill on the sidewalk, if you leave your idea unprotected, or even worse, you put it out into common knowledge, your ownership rights will not be looking too good. Because this concept of trade secret basically just extends state protection from stuff to ideas, state law governs. And there's a model law. This is one that's drafted as kind of template for states to adapt and later adopt in the interest of uniformity. It's called the Uniform Trade Secrets Act, the UTSA. California adopted this, lightly amended, as California Civil Code sections 3426 through 3426.11. This is commonly called the CUTSA or CUTSA. Okay, what's CUTSA all about? Think again about the $20 bill. If somebody steals it and you sue on the tort, you sue for conversion of your personal property. If someone steals your idea and you sue on the tort, you sue for misappropriation of your trade secret. So there are two elements, the trade secret and its misappropriation. Okay, you start with the trade secret. A couple of requirements. It has value from its secrecy, and it's being kept secret by reasonable security. Think about the recipe for Coca-Cola. It's valuable because people at Coke know what it is, and they keep it secret by elaborate means. What this means for you is that if you want trade secret protection for your idea, you need to keep it secret. A big part of this these days is computer secrecy. If you're keeping your idea on a computer, the security needs to be at least reasonable. Carrying it outside of work unencrypted on a laptop is going to be iffy, and a lot of other practices that you see reported in the newspapers. If you've got a trade secret and you're relying on that kind of protection, keep it secret. Then, for the tort of misappropriation of trade secrets, you need the actual misappropriation. In this context, misappropriation means the following, just as on the slide: disclosure or use without consent by a person who either used improper means or derived it from someone else who used improper means themselves. Basically, there needs to be some funny business in how the defendant got the idea. Okay, now let's look at patent. Patent protection is federal protection for certain kinds of ideas, and there are potential drawbacks. Unlike with trade secret, you need to disclose the idea. This happens in your patent application, so piracy can be a problem. Also, patent protection eventually expires. Finally, patent attorneys cost an arm and a leg, and if you intend to market the idea yourself, you're going to need patent litigators who cost the other arm and leg. On the other hand, patent has some real advantages. If someone else is likely to run across the idea soon, trade secret's not going to help you since it doesn't cover independent discovery. Okay. Finally, if you mean to sell your idea on to some big fish, selling a patent offers you a whole lot more protection than selling a trade secret. The fish is going to want to examine your idea first, and it's not uncommon in business these days for the fish to steal it and claim falsely that he or she developed the idea for themselves. So patent will protect you there. Now there are two broad categories of patent: inventions, which typically covers things and processes, and designs. Inventions have functionality, designs do not. Okay, so patents for inventions are sometimes called different things. For instance, if the invention is a process, it's common to call it a process patent. But I'm going to use the term product patent with the understanding that the definition of product is wide. A product can be a machine, it can be an assembly of machines, it can be a chemical structure, it can be a genetic sequence, it can be computer code. The test is functionality. Does the thing do something useful? If so, it's a product. If it doesn't, if it's primarily decorative, that's a design. Now for a product patent, there are 4 requirements. It has to be novel, that is, it's not known or used by others. It has to be useful, that's the functionality. It has to be non-obvious, that's measured by ordinary skill in the art. Ordinary skill. And then finally, it has to be invented by the patent seeker. For a design patent, the requirements are basically the same, except of course now there's no requirement of usefulness, because that's the difference between a product patent and a design patent. So how do you get one of these things? How do you get a patent? It's created under federal law, 35 U.S.C. sections 1 and following, and you start at the federal office called the United States Patent and Trademark Office, the USPTO. You declare your idea in a filing, and that lets you say it's patent pending, and if the USPTO agrees that your idea meets the requirements, remember the requirements we just looked at, you get your patent. So what can you do with your patent? It gives you 4 legal rights, just as on the slide. You can withhold your idea, you can develop and market your idea exclusively, you can license your idea to others to develop and market, and you can sue anybody from using your idea without your permission. It's this 4th right, suing for infringement, that is the teeth behind patent protection. How long does it last? Well, you need to know 3 things to answer that question. You need to know what kind of patent it is. You need to know when the protection starts, that's sometimes called accrual, and you need to know when the protection ends. In other words, how long does the patent period extend? Okay, so let's consider. Okay, remember the first question is what kind of patent is it? If it's a product patent, well, okay, a product patent accrues on filing, and its period runs for 20 years. Great. A design patent also accrues in filing, but its period is 14 years. So find out what kind of patent you got, find the filing date, and count off either 20 or 14 years. That's your period. 2 more things about patent, specifically about ownership. First of all, whose idea is it really? And how can she lose it? In this country, the owner is the first to invent, or who bought in chain of title from this person, but first to invent. Someone else can beat her to the USPTO, but if she was the first, her claim is going to prevail. This is called the first to invent rule. However, you can also lose the idea. The inventor can lose the idea by permitting its use in public for 1 year or more. This is called the 1-year on sale doctrine. Great, now let's talk about copyright. This is the 3rd area of intellectual property. Like patent, copyright is federal protection for certain kinds of ideas. It applies to works of authorship, not inventions or designs. That's the distinction between copyright and patent. Okay, so what are the elements? It needs to be original, needs to be a work of authorship. That really shows you that it's all about copyright, authorship. And it's fixed in a tangible medium of expression. You can't just have it in your head. It has to be authored. Okay. How long does it last? Depends. Are you dealing with a person who created it, or who owns it, or are you dealing with a business? If it's a person, the period of protection lasts for the life of that person plus 70 years. If you're dealing with a business, the term of the copyright is the longer of either first publication plus 95 years or date of creation plus 120 years. Okay, finally there's trademark. This is the fourth area of intellectual property. This exists under both federal and state law. A trademark identifies goods. A service mark, by contrast, identifies services. Pretty straightforward, just some terminology you want to be aware of. Okay, in both cases, whether you're dealing with a trademark or a service mark, the term of protection is going to be 10 years from registration. That's it. Intellectual property in a very small nutshell. What are the four pieces of the puzzle? Okay, trade secret, patent, copyright, trademark. Very good.